The Attorney General of the Federation and Minister of Justice Abubakar Malami on Wednesday in Abuja said his office would soon comply with a court order that he should expunge Section 84 of 12 from the Electoral Act 2022. This is just as the Senate and the House of Representatives separately condemned the court order and vowed to take immediate action on it. Recall that a federal high court in Umuahia had last Friday declared illegal Section 84 of 12 of the Act, which stipulates that all political appointees must resign before taking part in primaries. Addressing journalists after the virtual Federal Executive Council meeting, Malami said he would give effect to the judgment soon, adding that machinery had been set in motion for that purpose. Asked about the progress of the court's ruling, Malami said the process was still on. He stated, "My clear response is the fact that truly there exists a court judgment. By the judgment, the court directed the Office of the Attorney General to take necessary steps to delete the provision, which in essence implies that the provision should not form part of our laws. Whether it had been deleted or has not been deleted is linked to a function of agencies of government and associated relevant parastatals. But the true position of it in that respect is the fact that the government printers and indeed the Law Reform Commission, among others, that are responsible for the codification and gazetting of our laws are working naturally with the Office of the Attorney General to ensure that what goes into our laws are indeed in line with the provisions of the law. So what I'm saying in essence is that it is indeed a work in progress against the background of the fact that the Law Reform Commission is involved statutorily, which is a parastatal under the Office of the Attorney General. It's a party to the process of codification. The government printers, which are saddled with the responsibility of gazetting our laws on the request of the Office of the Attorney General, are equally involved. He noted that the possibility of an appeal was also there, adding that deletion of Section 84 of 12 is a work in progress and is being considered as such. But the National Assembly has resolved to appeal the judgment. The Senate and the House of Representatives separately reached the resolution at their plenary on Wednesday. The House resolved to report Justice Anyadike to the National Judicial Council for empowering Malami to delete the section from the Act. Mr. Onduka Edede, a lawyer and chieftain of the Action Alliance, had approached the court in the suit that had the AGF as defendant. The plaintiff had asked the court to determine whether Section 84 of 12 of the Electoral Act, when read together with Section 66 1F, 107 1F, 137 1F, and 182 1F of the 1999 Constitution, was not inconsistent. However, the Attorney General of the Federation, who was the defendant in the case, supported the plaintiff, and the judgment was delivered barely a week after the suit was instituted. The National Assembly and the Independent National Electoral Commission (INEC) were also not joined in the suit. Meanwhile, a member of the House, Sada Soli, raised a point of order to say his privilege as a lawmaker had been breached by the courts. Soli said, "I'm coming on privilege with respect to the institution of the House of Representatives, reading from various reports of the recent judgments or pronouncement on the law made by the National Assembly. Mr. Speaker, this judgment is not only an insult, but it is an attempt to oust the jurisdiction of the Parliament in making laws by directing an appointee of the executive to delete a law made by the National Assembly." The lawmaker made reference to the judgment in Olisa Agbakoba San versus National Assembly as contained on page 2100, paragraph 15, Legislative Laws Report of Nigeria, which partly reads, "Courts cannot read into or import into the Constitution what the legislators never intend." He explained, with respect to Section 84 of 12 of the Electoral Act, the intention of the legislature was to address the issue of political appointees, which was never addressed anywhere in our Constitution. Solely recall that the President, Major General Muhammadu Buhari, retired, was advised to communicate to the House with respect to Section 84 of 12 to request the Parliament to delete it. And I'm sure that the advice was given by the Attorney General of the Federation because he is the chief law officer to the President, the lawmaker said, adding, "But suddenly we are waking up to see a judge somewhere giving that right to an executive appointee and encroaching into the principles of separation of powers." The lawmaker also cited the judgment in the Attorney General of the Federation versus Atiku Abubakar on page 1838, paragraph 5 of the Legislative Law Report of Nigeria, which prohibits a court from enacting or writing into the Constitution or any other law what the makers failed to insert. The minority leader, Undudi Elumelu, also raised privilege and constitutional orders to cite section 66(1)f, 107(1)g, 137(1)g, and 182(1)g, which prescribe the conditions for a public servant seeking to participate in politics. Elumelu said, "I'm taken back in the Constitution where there is separation of powers and where we have been made by the provisions of the Constitution to make laws that somebody is trying to do our job. I'd expected that whatever that the judiciary would do was to interpret and in the course of interpretation refer back to the National Assembly and not ask the executive should do the job of the National Assembly. That offends the spirit of separation of power." In his submission, Herman Hembe said he was worried that the same wordings that were contained in the advisory given to Mr. President, which was sent to this House asking it to delete a certain section of the Electoral Act, happened to be the same wording that were presented before the Federal High Court. Hembe also noted that the plaintiff refused to join the necessary parties that made the law he was unhappy about, as well as the presidency. He therefore urged the House to immediately appeal the matter. Meanwhile, the APC is set to bar political appointees from voting at the party's national convention and primaries until the Supreme Court decides on the controversial Section 84 of 12 of the Act. A chieftain of the party who wished to remain anonymous because he was not permitted to speak on the issue said, "The matter has become too controversial and it would be risky to do anything that could jeopardize both the primaries and the convention." He said, "The matter is too controversial. We don't want to risk the convention and primaries being invalidated because of a few political appointees. So, we may be proposing that political appointees should not be allowed to vote at the convention or even at the primaries until the matter has been settled by the Supreme Court or the National Assembly. This is most likely what the caretaker committee would do, although it has not been finalized."